Jen, Jen Samparisi, please report to the office.
Mic on. You good? All right. 5:30. That's loud. 5:35, and we'll call to order the Keene Board of Education Policy Committee meeting for April 22nd, 2025. There's no public, so no public input. Public input can be submitted via email to spelke@sau29, indicating that it's input for the policy committee. And to approve the minutes of March 25, 2025.
So moved.
Second.
Corrections, spelling errors, nothing. All right, all those in favor? Any opposed? Carries 3-0. Who is our fourth?
Jeff.
Huh, interesting. All right. First up is IJOA field trips. This is for second read. We didn't send this to full board. The only change at this time was to remove out-of-state field trips. We're leaving in overnight and
Out of country.
out-of-country field trips, pending some other reviews. But we decided to put this in place now because it would help the high school, especially for the rest of this year. And then we'll probably take a deeper dive on this at some point to figure out, because as we've discovered, we don't actually need this policy at all. So we got to decide what we want to have control over and what we're willing to just cede right off to the administration and let them develop procedures and handle it. But if nobody's received anything else on this one, all right, then can I have a motion to present this? Motion to recommend.
Yeah, I'll make a motion to recommend to the full board policy IJOA field trips and excursions.
Second.
All right, with no other input, all those in favor? Any opposed? Carries 3-0. All right, more complicated is the next one, which is ACAC. I have the wrong month. That's not helpful. All right, let's do this one in the correct order. Can we have the motion for recommendation first?
So moved.
Second.
All right, and then we'll do discussion. So this went to the board as a first read. And what we have available to us in the drive is the one that Adam went through and did a lot of work on, for which we appreciate. And I think, Rob, this is going to come up as a theme over a lot of things in this committee and at the full board. What we're going to have is the legal documents that we have to do a certain way, and then we're going to have a separate discussion, I think, on how we continue to provide protections for students whose existing protection has dropped off of a number of these official documents. But
yes and no. So it seems like specific classes of folks have been dropped off of protections, but discrimination, we're still not allowed to discriminate. And so those protections still exist, regardless of anybody's background. So yeah, it seems pretty targeted and it seems pretty pinpointed, but I still believe that we are beholden to the laws of our land and that folks still have protections regardless of what we're hearing from Washington. So I stand pretty firm with that, in that we still have obligations to protect all of our students and make sure that they are not being discriminated against. So I hear what you're saying, but I do believe that how we practice, we're in good shape.
I would agree. Hang on, Adam, let me respond to that, then I'll hand it to you. I would agree with everything that you just said. And I still think, and this isn't the committee for this discussion, I think that we need to bring that discussion to the full board, because I'm hearing things from principals that there are elements of our community that are empowered by state and federal government at this time, and that those protections are eroding in our schools despite best intentions. So how we move forward as a community has to be looked at.
These are changes just to ACAC and Title IX sexual harassment policy. There are still, to Rob's point, policy AC regarding non-discrimination remains intact. It's just that we are bound to follow the federal interpretation of this, is what we've done here. And I think that these revisions that the full board has at least read once now, follow that.
Your mic. Might want to move a little closer.
Sorry about that. I forgot about the mic. So as I was saying, Title IX, these are changes regarding the interpretation of Title IX for sexual harassment, discrimination. We still have AC, policy AC for.
It's off again.
Green is
Yeah, just like
Let it-
yeah.
Oh, I can't hold it?
No.
First time, long time. So as I was saying, sexual harassment under Title IX has been revised to comply with the interpretations under the current administration and federal guidelines. But policy AC regarding non-discrimination remains intact and is still on our agenda and still on the books here. So to Rob's point, we still continue to protect against discrimination.
All right. We went through this last month, yes, with Adam's comments. You haven't made further changes to this?
I've made no other changes since last month.
Okay. We refresh my memory, Jacqueline, you might remember this better than I do.
Mhm.
We went through this pretty aggressively on the calendar days versus business days stuff. Is that this policy?
I think so, but let's just double check
It's on
rather
page,
than assuming. I think we did.
yeah, it comes up on page 2. I ask because I got input from the board. Someone
Oh, did you?
recommends that we
Okay.
change calendar days to business days. And I think that we
Yeah,
actually
I
talked
see in
this out.
page 2 under section B for definitions, days
Yeah,
in quotes shall mean calendar days, but exclude non-weekend days on which the SAU office is closed, i.e. holidays, office-wide vacations.
yeah.
Should it really be,
Yeah, go ahead.
not getting too deep in the weeds, office-wide, but more district-wide vacations? Or school district vacations?
I think,
We're not just an office.
yeah, but I think it's SAU office because those are
Okay.
the days that the superintendent or designee can be accessed.
George, if I may, that
Yep.
language is direct from the NHSBA version,
Okay.
and it mirrors it exactly to
Yeah.
account for things like snow days and days that, like you say, the superintendent cannot respond.
Yeah, and I do. There was 2 policies that we really aggressively looked at that calendar days versus business days, and I think that this was one of them.
Most of these restrictions, like in JICK regarding bullying, also follows school days
Yep.
as the period of time during which the school has to react, because we're not going to force people to come in on their days off to address this stuff. We're implicating collective bargaining agreements and all that other stuff. So we typically follow school days.
Yeah, and this one's written differently to say calendar days because the school days is only limited to 180, but yet the superintendent's office and many of our schools are open 260 days out of the year. So that's why it's written calendar days and not school days. If they use school days, it would have limited responses during the actual school year calendar.
Oh yeah. Good point. All right. Anyway, that answered my question. We already beat that part up. All right. I also had a comment on page 10, which I can't find. Hang on.
When you say there's another comment that you received, is that from another board member or member of the public? Just
Board
asking
member.
for clarification.
Board member.
Okay.
Paige Walker went through all of our policies.
Okay.
She also had a bunch of grammatical, like add a comma. This
Gotcha.
letter is duplicated, but I'm just going to provide those to Shana because they don't substantively change the meaning of anything.
Fair enough. So page 10, which area?
Adam had a comment about actual knowledge and whether that should be capitalized.
Yeah, I was just raising the point that actual knowledge isn't really defined here or in the NHSBA's policy or by statute. I mean, who has actual knowledge, right, of the harassment? The district is not a human being, right? So that's just something I raised to think about is when would we have actual knowledge? And I guess I would say it's when certainly when the superintendent has it, or I think it could be read to say when district employees have actual knowledge. So we should just be mindful of that in implementing it.
Yeah, that's pretty much what the comment is too. Hang on. Where did it go?
Yeah, it's not clear who has actual knowledge.
Yeah, actual knowledge should clarify who has the actual knowledge.
Yeah,
Yeah.
I agree.
Right.
So it says the district will respond when there is actual knowledge. So I guess I might say the district will promptly respond when there is actual knowledge by district staff of sexual harassment.
Yeah, that would certainly make more sense because, as written right now, a parent could have actual knowledge, and technically that would trigger our policy, even though nobody in the district knew about it yet.
Yeah.
George, if I may?
Yes.
Just so it's noted for Shayna, that next sentence, complaints is misspelled. We got an extra A in there. COMPLAINTS. Where you've got your cursor now, and then the next sentence, the district shall treat complaints.
Nope, it's complainants. It's the people bringing the complaint.
Complainants. Okay.
Yeah, so there should be a T, complainants.
There we go.
Yeah, I think that whoever wrote the NHSBA sample didn't know how to spell that word.
Right where the 3 is, there's another one
Yeah.
that needs a T.
Down.
It's in the middle of the
Yeah. Get your mic on.
Yeah, what was that 3 doing? Google doesn't like it, so maybe it isn't spelled with a T. I will confirm that offline. We don't need to waste time trying to figure that out. All right, and all of the rest of the comments from Paige are grammatical, and I'll just make sure that Shayna has them. A lot of like replace her, him with them, that type of catch that we usually work on when we see them. But this is such a long policy that we missed some of them. All right, anything else on this one? Any concerns with passing it to the full board? All right, motion's already on the table, so all those in favor? Any opposed? Carries 3-0. All right, policies for first read. More fun. All right, these are the first couple here are the ones that we put off last month, so we get AC in place, and then we'd start looking at these, but it's the same deal. It's been changes in federal law, and we had to get these to match. And Adam again has gone through, and I believe, Adam, that Shana, what Rob's going to have up on the screen is your edits that Shana was able to pull from last month.
Yes.
Okay.
Yes.
All right. Why are we removing handicap? Did the law change? Did we write on the title?
I'm sorry, say that again?
Right on the title, you've removed handicap. Is that a law change?
Microphone.
Is that just an irrelevant point?
No, I think that's just consistent with our policies that we're using the word disability,
so. It's
which
just
would
left
encompass
over from-
handicap.
So it's just left over from.
Yeah.
Yeah.
I don't think that came from me. I think I put that in because of discussion at this committee at some point
Probably.
in January.
Oh yeah, these comments have been in place for a long time. Yeah, we must have looked at this in January, and then you went and did edits to it, like
I think that's right.
yeah, 2 days later. Yep. there's not a ton to this policy for how long it is. The major change is that added paragraph on halfway down page 1. Which I assume is why we had to have been looking at this in the first place.
So that language comes from the NHSBA version, so I've moved it over in here. One of the things that I would note to the committee is that we have policy IHBA, but we do not have a procedural IHBAR.
That sounds familiar. Did we not address that at some point?
So what?
It would appear not.
Yeah. So we can in our policy we've got a similar paragraph about compliance with anti-discrimination laws, and there's a whole list of them.
Yep.
We could, I think, delete that paragraph about compliance with anti-discrimination laws, because the paragraph that I've inserted here already says that the district will ensure that all parents, guardians of students with a disability are provided all necessary procedural safeguards as are required by law. So they're sort of in there. Where are you? Oh, we do have IHAVR. Okay. April 15th.
Yeah, I thought we had addressed that.
Okay.
Yeah, and if it's dated the 15th, that means we just approved it at the board meeting.
Excellent. Okay. So then you can
Yeah,
strike
go us.
my concern about not having it.
Yep.
So it's a little redundant to have that compliance paragraph there, but I don't have a problem with leaving it in there. I will admit that I didn't cross-reference every one of those citations in the paragraph. They don't tend to be moved around a lot at the federal level.
Yeah.
But especially laws like these that are cross-referenced at so many different locations.
All right. Yeah. So yes.
I would tend to say I would prefer to have that compliance with anti-discrimination laws, as you said, Adam. It's cited in others, but I think it's just it's not hurting anything if you feel it's not, and I just feel it's a good sort of consistent measure, particularly if somebody goes online and they pull up just this policy. It's there at the ready rather than having to fish around and find it cited somewhere else.
Yeah, I don't have any problem leaving that stuff in there. I think it's incorporated, but loosely, whereas this is more specific.
All right. I don't have page numbers, but all right. So you're saying we probably don't need that compliance with anti-discrimination sentence?
Only because the paragraph that I inserted from the NHSBA version references as required by law. Those are the laws that are required, so it's a little redundant, but it's not hurting anything.
Yeah, I'd rather leave it. Rather
if people need to know where to look.
Yeah, it doesn't add to your workload to have it in there twice. So, you know, it's not like you're going to go back and comply twice with everything. Hopefully the first time covers it. All right, scroll on down a little bit. Under B, we get a hanging sentence. The second sentence under B, either request shall be delivered to the above cited the complaint. That's a nonsense finish. And I'm not sure what it was trying to say. Either request. So the possible requests are A, you can request the board places this matter on its agenda, or B, notify the superintendent.
Right, so that's probably a new paragraph starting either.
Yeah, but there's only one request.
Either of
these.
How about other
you may A or B.
Yep.
Yeah, but you're not notifying the superintendent is not a request unless B should say request that the superintendent, but it's not really a request because it actually is, once it gets reported to somebody, it's required by law to be investigated. And then shall be delivered to the above cited the complaint still doesn't make any sense. So I'm not sure what we're going for here. at all.
It should be cited.
Either request shall be delivered.
The above, citing the complaint.
Okay.
Yeah, comma, right.
All right.
Cited
And
to
then,
the
but then
above,
request
comma.
is incorrect because that means either the request to the board or the notification to the superintendent shall be delivered citing the
Comma,
complaint.
not hyphen.
Yep. Oh yeah, that fixes that. Either option, either short choice.
George, if I may,
Yes, go ahead, Jack.
that next sentence, the you may be, I would seem it would be more appropriate for it to say the complainant may be represented, not you.
You may
The
be
policy isn't
represented.
directed to
Yeah,
the person, right? We talk in neutral.
anyone of your choosing may present. That's a broken sentence too. I'm wondering if we should check. Is this ours that you
I
marked up,
think this
Adam?
was a very
This is
old,
this is the Keene School District version. This
I'm
is
wondering if the NHSBA version that we copied this from in the first place had a better paragraph there that we accidentally broke.
it is not included in that.
Oh, good.
well, and if you look at the bottom, I mean, it's gone through many iterations
Yeah,
here, so.
because there's definitely some stuff dropped from that.
Sure. What it says is more specific information regarding the district programs and procedures. Oh yeah, we already have that in there about IHBA.
Yep.
But this appeal is our own. It is not contained in the NHSBA version.
All right. So what the heck are we trying to say in this little subparagraph here?
Go fix something on paragraph 2. The parties will attempt to work out their differences informally,
That's good.
comma, promptly and equitably. Equitably, informally doesn't really work.
Yep, that's good job.
Going back to days, we've got 10 days. We haven't specified if that's calendar days, business days.
It says working.
Where are we?
No, the director of student services will make an initial response within 10 days.
Oh, sorry, I'm just 2 lines below where it says working.
That's okay. Yeah, actually, in the last sentence, it's got 10 working days, but the sentence above has just got 10 generic. Perfect. Thank you, Rob.
So if that step fails, you may request that the board put this matter on their agenda or notify the superintendent. I'm going to capitalize the first letters in those.
Yep.
Now
Ask
we
a
work
question,
through this
Rob?
last little
I mean,
couple sentences.
What do you got, Jacqueline?
George, just looking down through, I don't know if I've jumped ahead now, but under the procedural safeguards
Yeah,
section.
you jumped ahead.
Yeah, we're
Sorry.
Because this mini paragraph is still nonsensical. And so Jacqueline's right. It's not you may be represented.
Right.
Well,
Well, it's also in the effort.
parents.
If that effort
Yeah, the
fail,
parent
you
slash
may.
guardian.
It's all in the.
yeah.
It's all in that.
Yeah, but that shouldn't read you may either.
Should we put parent slash guardians?
Yeah, I
If
thought
that
that's what.
effort fails, parent
The
slash
parent,
guardians and parent slash guardians.
Yeah, be consistent in all previous instances. We've said parent in the singular.
Oh,
So currently it reads that parents or guardians may be resented by anyone of your choosing.
We're missing the P.
Add in an REP. Where are you going?
Sorry, Rob's just highlighting this to show the change
Mm.
because he's in editing mode instead of suggesting.
Again, just to reiterate, shouldn't it be parent in the singular since we've said parent/guardian in the singular everywhere else? And you could
If
begin that sentence with the parent/guardian.
we're going to be really legally nitpicky, then it probably should be parent parenthetical S / guardian parenthetical S
And that's
every
fair.
time.
Mm-hmm. Yep. So then let's do that accordingly throughout the
It just
policy.
feels painfully pedantic, but is probably correct.
Mm-hmm.
So, Rob, up above A, if that effort fails, the parents, guardians go in over you as well.
Switch to suggesting. So Maddie S, parenthetical S is here as well.
Yeah. And then you need to correct. It's not resented, it's presented. You need a P. PRES, presented by anyone.
System overload here.
That's okay.
Where the heck are you? Oh, that's up from there. Okay.
Where are you?
Back down to where we were under grievance procedure, section B as in Bravo. PRES. Yeah.
And then
Yeah.
that should be parents, guardians as well. Because that is one of the things that was bugging me, and I couldn't figure out why, is that it was
Mm-hmm.
much too informal when we're just saying, hey, you can, come on in. And
Yeah, the policy's not written to be, first person directive to an individual.
all right, either request shall be delivered to the above citing the complaint. Parents, guardians may be represented by anyone of their choosing and may present information through documents and other nope, sorry, I'm wrong. Yep, anyone of their choosing. And then the rest of it actually works. May present, parents may be represented, may present information, and may examine witnesses. Yeah, so the rest of it works. And I guess it was the informality of it that was completely throwing me off on the whole paragraph. All right.
There's one more
You've
place
got
where
something else,
we're
right?
missing the parenthetical S. That first sentence right under the heading of grievance procedure, at least for what I'm looking at now. But maybe you've got it. Great. Thank you. Oh, there's one more place where we've got a U instead of the person under the procedural safeguards. But again, what I'm seeing, I'm not seeing the suggestions and all of the edits. In the first paragraph under the header of procedural safeguards, which starts with as required by section 104.36, blah, 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 blah. And then the second line down, see where it says need special instruction and related services, comma, you have the right. It's not you. It's the either the student or again the parent or guardian.
Rob, I'd suggest you strike the as in front of that area you're editing to. As required by section 104, the parent / guardian of a student. And then you just get rid of you have and say has the right.
And related services, comma, yeah.
Has the right.
Yeah, you strike,
Have the right.
just say the parent, the parent has, because it's singular without those parenthetical.
I'm going to once you get that edit. Upset the whole apple cart.
And there's another U reference in number 3 of that.
Five, 2016. It was frustrating. I was on the policy committee that did this the second time.
So it is going to do this for participation and representation.
Yep.
Yep.
Which means I let all of this. Of course, that was my first year on the board too.
And then once you've done that, Rob, you'll notice that number 2 on this is sort of word wrapped into number 1, so we need a hard carriage return. Please and thank you.
All right, now you guys ready for me to really upset the whole thing? Adam, you're saying that the grievance procedure is ours, it's not written in law?
That's not what I said. I said it's not in the NHSBA version.
Ah, okay.
This
So,
this likely does derive from law. Off the top of my head, I can't tell you where, but I suspect it's Section 504. But I don't know where we. My point was that the NHSBA version of policy
Didn't have
ACE
this
does
sentence.
not have this grievance procedure.
So our normal grievance procedure would be the complaint goes to the Director of Student Services and they make a response. And if they are the parents are unsatisfied with their response, they go to the superintendent. And if they are unsatisfied with the superintendent's response, they go to the board. The way we've written this, they can choose to skip you. And in fact, the exact way that we've written this is going to read like a recommendation to skip you.
Yep. Good catch.
I mean, we can leave it that way, or we can rewrite this to match what we do as a grievance with everything else. Unless we think there's a law that says they have to be able to go right to the board, which would surprise me.
It might exist. I don't know off the top of my head, but I'd be happy to look into that.
Yeah. I didn't expect you'd have that such an esoteric thing to have memorized. Assuming it's not in law, can we think of a reason that it would work this way instead of the way we normally do it?
No.
Because you have, on occasion, sided with parents rather than the other people in your office. It's not a rubber stamp. So, I mean, it's not a hugely difficult. It means that, let's see, a written resolution. So the rewrite, don't type any of this down yet, would be, normally we would say, if the parents are unsatisfied with the response, they may, within 10 working days, submit a grievance in writing to the superintendent citing the original complaint and what redress they're looking for or something to that effect. And then you would have 10 days to respond, and then they would have 10 further days to appeal to the board, and we would have to schedule it.
Yeah.
We can probably pull the language from somewhere else.
I agree with their line of thinking there. The only thing that gives me pause is that these are procedural safeguards that would be spelled out in IDEA. And so if Jen, you'd be kind enough to make a note in the minutes to have this portion of the policy reviewed by the Director of Student Services to make sure it matches both district procedure for grievances as well as procedural safeguards. I just don't know off the top of my head.
No, that's fine. And even that's the correct route. We need to make sure that we're meeting everything. So this feels significant enough to me that we table this for a month. I think we need to have the proper grievance procedure in there before we bring it to the full board. Unless there's a reason that we need this approved immediately, which I'm not particularly seeing. We didn't make major changes to this one.
Yeah, I don't think there's a rush on this, George, so I think we're okay. but if we wait a month, then it's going to be September.
Yeah. I mean, we can try first read, but
Yeah.
this change probably won't be ready for first read, so that's
Which is
dicey.
okay, which is part of the process, right? So we'll double check that piece, and
Right.
if there's a need to change, we would prep that up before it goes to second read.
All right, so we bring it for first read, and if for some reason it doesn't work that way, then we take another month, but then we have the option next month to say, let's move forward. All right, that works for me. All right, anything else on ACE before we move on? All right, AC, non-discrimination.
Are you guys still doing open comment? I don't mind waiting.
Public input?
Yes. I'm happy to wait till whenever it's convenient.
Yeah, we started late, so he's just barely. Yeah. Why don't you go ahead and get that in because you're still inside your half hour.
Oh, no.
Just barely, but yes, you're still inside your half hour. And I'm sorry, I should have asked when you came in. I didn't even.
I just had a question about.
Wait, just, put your microphone on.
I had a question. There's been some articles in the Sentinel recently about the reminder of legal obligations undertaken in exchange for receiving federal financial assistance. And I know most superintendents have signed it and signed off on it. I also know that a few have brought lawyers into it and are pushing back against it. I guess my question is probably more for the attorney, but what are we agreeing to with this? Or what are you agreeing to with this?
So, we're actually, Rob doesn't know this yet because we haven't had the agenda planning meeting, but we're going to put this topic on our full board agenda to discuss there. And actually, we have to anyway because the other half of, so there's actually two documents. One of them is signed by the superintendent, one of them is signed by the board and the superintendent. And Rob brought that to us last month and we tabled it for a month for review.
Okay.
So that will be on our full board agenda to discuss both of those documents and what they mean for the district and what we're actually signing on.
Okay, that's great. I'm glad to hear that. I guess my other question, as long as I'm up here, I was looking at the agenda, and there's a bunch of tabled items, and they all seem like items that might somehow be related to this topic of DEI and things like that. Is that accurate? And is that why they're tabled?
Policies on hold? No.
The policy is on hold. That is what I
some
mean.
of them, they're on hold for different reasons. Some of them are, actually, well, yeah, they're all pretty much on hold because we're waiting for clarification from other sources. Some of them have legislation that's moving through right now. Some of them we're waiting for rules from the Department of Education. Some of them we're waiting on court decisions. So,
Right. Okay.
so yeah, basically, we're waiting for external forces to decide what our legal obligations are before we tackle them.
All right. And is there a deadline? I know that a couple of the superintendents rescinded their signatures to join into that lawsuit. Is there a deadline on that, or
To rescind?
yes? I mean, I guess I'm just wondering if. Yeah, that is what I'm wondering.
So you're talking about the Title VI documents that were due in the middle of April. So that time has come and gone. And there was only one superintendent that I'm aware of that actually rescinded theirs. Everyone else did end up signing.
Okay. All right.
Yeah, that one was due 10 days, right, to sign that one. Yeah. And then the one that we're discussing has to be signed by June 1st, I think.
Yes.
Yeah.
So what would happen if
the general assurances is due on June 1st, but the Title VI document was due April 17th.
just out of curiosity, what would happen if the board decided not to sign that, but you did sign it? How would that be? How would that play out?
We'll address that at the full board because I know that's a question some of the members have as well.
All right. Okay. Thank you.
And I didn't prepare, or Rob didn't prepare to have coherent answers tonight,
Yeah,
so
no,
we'd be kind of winging it.
Sure, I understand.
Yeah. Oh, Jason, can you just give your name and address for the record? We probably have it.
Sure. It's Jason Washer, Roosevelt Street in Keene.
Thanks, Jason. All right, and now we're about half an hour after we opened public input, so if anyone else wanders in, they'll have to hold their input. All right, where were we? We just did
AC-R.
Oh, that's right. Which we're hoping to rescind. Is that correct? This is on the books now, and it's required by law. So why is it listed as a rescind? This was approved about a year ago. Probably pretty close to verbatim. Oh, it's absolutely full of Title IX references that would have been to
It's the contact information.
Yeah. And was this required by law by the 2024 Title IX that went away, and that's why we're removing it?
That's unclear.
What's that?
It's unclear whether it's required by law to have these specific addresses and whether those will be accurate for much longer. Who knows? Well, no, these are accurate here. These are ours are, but some of these other, Boston addresses and federal offices.
Oh, yeah, that's right. Yeah, but we listed this as rescind in the agenda. I'm not sure why we did that. Maybe we didn't. Maybe that's...
There is a cross-reference to it in policy AC.
Yeah.
In subsection E. So I think we probably want to just leave it for now. Because it says in our policy that the contact information for such agencies is located in AC-R. So,
All right. And then required by law usually means that we have to pass it as a board, which means it's not an administrative procedure. It's a board-approved procedure. I don't know. I'm unclear why we even have this on our agenda, because it exists in the books and we're not looking at making any changes at this time.
Unless it was a recommendation that came from NHSBA directly.
All right. Can we have Shana check that out?
Yeah.
All right. And we'll just move it to next month to figure out what we're doing with it.
I may have said, and it might have wound up in the minutes, that I wasn't sure whether it was required that we have that, because it isn't really a policy. It isn't really a procedure. It's just a list of contact information, and we have it. Have it listed as a procedure, but it isn't a procedure.
Yeah.
So that may have wound up in the minutes in that fashion. And if that's confusing, that's on me. I don't think it's hurting anything as long as these addresses are current. And I note there are email addresses, but the ones that we have here, like I don't know whether the 504. I thought we were going to work on. We've got Kate Adams' email address here. But that if there is a 504 coordinator at sau29.org, we should use that address instead.
That's correct. That's still accurate.
Okay. Something to think about.
Yeah.
Like we have a human resources, we have a superintendent at. We may want to get a 504 coordinator at email address.
Yep. If memory serves, we discussed that last month.
Student services
to have a generic email.
Yeah.
Yeah. And you did bring up the fact that the federal and state offices might disappear, or especially
the
regional one may be
right.
We might only have 2 regions instead of 8 regions.
That is something we should probably keep an eye on.
Yeah. All right. Yeah. Rob, why don't you have Shannon check with NHSBA with what we're actually required to have for this one? Because Adam's right, it is weird to call it a procedure, but it is also referenced by either AC or ACAC. So if it's referenced, it has to exist. So we got to figure that part out too. But we're not going to bring that one to first read because we're not doing anything to it. All right. Policies for review. And I asked for both of these. That was it, right? That was all you had for first read. That's all we had for first read. Okay, everybody's good with the discussions we had there. All right. JICK, pupil safety. And as I was telling Rob, I basically came straight here from Allentown, Pennsylvania, so I'm a little less prepared for this meeting than I would have normally been. So I don't remember where this falls in this policy, but the superintendent and I were responding to an email from a parent that was referencing this policy, and I had a light bulb go off in my head about one of the complaints that we get frequently as board members is I reported bullying to a teacher, to a principal, and nothing happened. Now, we know that part of that is because something very well could have happened, but that information is protected by FERPA and cannot be then relayed to the complaining parent. There may have been consequences, even if it wasn't determined to be bullying, there could have been consequences for the student involved, and that information is never going to be relayed because it's protected by federal law. And I know parents find that infinitely frustrating, and I understand that as a parent, but I also understand as a parent wanting those protections for my kid if it's reversed. So I get all of that, and we know that that's part of it. But the other part is, do you remember where this was, Rob? Do you remember what I'm talking about?
I've got it on the screen, and it was a
perfect.
procedure for reporting.
Yep.
It had student reporting, and it had staff reporting, and Adam put in another section, a recommended section, which would encompass anyone else.
Yeah, and I'm not sure that's the right procedure. I just made that up. But
Okay.
there should
But
be
yes,
the
this
ability
is-
for any other person to report, not just students and staff.
Yep, that was part of it. That was definitely part of it.
That was the one that was like, well, how do parents report? Because
Right.
it's not referenced in our policy.
Yeah, and you and I talked it through and agreed that
Yep.
as standard procedure, it was still treated the same way, but it wasn't written that way.
Correct.
And there was also something a little bit vague in here about reporting in writing versus reporting verbally. Obviously, when people talk to us, we always, as board members, we always recommend put everything in writing because then there's that train. An email or a letter triggers everything, the 10-day response period, all of that. And verbal doesn't have that same power. And I know that many parents want an issue with their child to be addressed, but they don't want to make life hard for the teacher and will then not emphasize that they think their child is being bullied. They will just say, hey, can I talk to you about so-and-so? They're kind of having an issue with my kid. And if the teacher's not hearing the word bullying, it may not necessarily trigger the response. And then the parent thinks that they have reported bullying, but because they didn't use the word. So somehow that this policy is provided to everybody, all students, all parents. And it feels like we should emphasize, I'm not sure the accuracy of the report or the fact that it needs to be in writing.
A preference for writing, perhaps?
That would work.
So let me go to suggesting mode here, and I'll add that to the end of that paragraph that Adam had already started.
Right. And to be clear, I think that what we have should have been good. And the addition that you put in was vital because that was one of the issues that technically a parent report did not trigger the response.
I went through it again too, just based on, because I saw it on the agenda and I went through and compared it against the statute. And there were a couple of things we were doing better than what the statute requires. As far as our definition of cyberbullying, it's more encompassing than the statute. We just said sort of mobile devices is a broad term as opposed to what the statute says, cell phones. So I think that's one of the things we're doing well. There were some other changes I included in here just that I caught, and this was one of them. This any other person needs to have an avenue to report, and then I just sort of filled in. The statute says there has to be a statement that bullying is prohibited. So we did more or less say it, but I just came out and said it. There were a couple other minor issues that I corrected that you'll see in the suggesting mode there.
Sorry, just while we're in that section,
Yeah, about any other person. I'm not sure that reporting it to the principal is the right place. I don't know where
yes,
it is.
absolutely,
Okay.
absolutely.
I figured it would be, and I tried to say reported to the principal overseeing the school in which the incident occurred or to which it was related. So that would say if it's a middle school sporting event, it would go to the middle school principal. That was sort of my intent there.
Yeah. No, I think the paragraph reads well. I think it addresses what George and I were discussing, and all I wanted to do was, any other person. I wanted to be very specific that it included parents and guardians.
Yeah, and that's. I mean, I don't think we need to beat the heck. I'm glad that Adam. I'm glad you went through and caught where we were missing and noted where we've actually been proactive. But I don't think this needs to be a deep philosophical discussion. We've already done that on this policy a couple times. I think it's just important to catch this and maybe reduce a few of the controversies that we have. Nothing's going to make the world perfect if your child is being bullied, but anything that we can do to make this a more user-friendly policy, I think, will help. Yeah.
Speaking of imperfect, you may remember this from when we revised this policy last in 2022. If you go down to the end about audio recording, the statute is, I think, imperfectly drafted about audio recordings and on school buses. And I included to the right there in the suggestion in my comment what the actual language is of the statute. So section XVII is fine. It says that, it tracks the statute saying that a school bus company may allow audio recordings along with their video recordings if, the school bus wants to do that. But then in the very next paragraph within the statute, it says prior to any audio recording, the school board shall hold a public hearing to determine whether audio recording should be authorized in school buses. But it's a private company doing it, so it doesn't really make sense. And I think what we addressed when we talked about this last time is that my feeling is that any audio recording means all of our recording equipment. So we have cameras on school premises elsewhere. So before we can record the audio on those, we have to have the public hearings. Scroll down a little bit, Rob. You'll see the next comment. Oh, where is it? There. See that? There's the statute, 570-2A, and it's K2. Ooh, sorry. It's a touchy little mouse pad there. But it's really not worded great. The statute itself says prior to any audio recording. It's not specific to school buses, but then it goes on to say school bus recording, which doesn't make a whole lot of sense. It doesn't jive with the previous paragraph that says a company that has school buses may record audio along with their video. So when we edited this last, I think what we decided was that we're going to apply this to any video equipment that the school board, any video recordings, wherever they are, whether on the buses or elsewhere.
Except I remember this law came into play right when I started, and it was pretty specific that, one, you can't use video inside a classroom.
Oh, yeah.
And two, if it's in the school building, it can't have audio.
It's the safest way to do it.
Yeah. And we did actually hold a public hearing at the time to address that. the loose end was the school buses, and so I think that the audio only applies on school buses. I don't think you can use audio recordings, and none of our cameras are actually equipped with audio anyway.
Okay.
So
Well, our policy is written to permit it if it were to be permitted elsewhere.
Right.
But we're not doing it.
Yeah.
So
Yeah, do we have audio capabilities for any of this equipment?
the only equipment that does are um, the cameras that we put in for the fields and the playing courts. That's the only one that picks up sound.
like the pickleball courts out here and
No,
No.
like at the football,
The football field
in the
Gotcha.
in the gyms, and
Yeah.
I believe even in our auditoriums.
So, Adam,
yes.
those are not um, I don't know, put in for security purposes. Those are put in for the purpose of, live streaming a baseball game.
Yeah.
Eventually, we're hoping to put it into live stream from the theater. Would those still apply would this law still apply if we wanted to use those videos for disciplinary purposes?
Yeah, I think so. I mean, it's so broad and poorly written. It says any audio recording.
So, Rob, do you think it makes sense for us to schedule such a public hearing in the event that the administration wants to ask the bus company to? I don't even think the bus companies do video recordings, honestly, at this time. I know Tim has asked them to.
I think that we're a little early on a
Okay.
public hearing just because we're working on a contract with busing right now.
All right. So then just you and by extension your principals need to be aware that surveillance video that includes audio cannot be used until such time as we have held a public hearing.
Correct. Can't use the audio, but you can use the video.
Right. All right. And then other than that, did you guys see anything else on JICK?
Just some housekeeping things. Would suggest Shayna goes through this. There's a couple of places where I see just parents, not parents/guardian. For instance, under the section about communication with parents upon completion of investigation, this is down on page 8. That should probably be parent/guardian. And then in number 3 of that section, just says parent. So, if you're comfortable, George, I would say we could just have the minutes cite that, and Shayna can go through a sweep, do a find now, and
Yeah, that's fine.
grab all of that. And then just another item that caught my eye. Bear with me, I'm trying to find it. It was about all different devices, and it included pagers, and that I think seems well done and gone. I don't think pagers are really going to be used anymore in
It comes
our
straight
school
out of the
settings.
statute. Unfortunately, that language is in
We
the
have
statute.
to.
Yeah.
Statute. Okay.
Yeah.
Good enough. Fair
Yeah.
enough.
They might make a comeback.
You never know.
Text pagers, those exist.
All right.
Can I throw in just one other
Oh
thought?
yeah, please.
And again, I don't know if this would go out of line of the policy or if it's more a procedural thing. But as you mentioned in your initial discussion, George, there's often the outcome is not shared because of FERPA, and that becomes frustrating. Do we have some sort of language in there? And there actually may be something already, but just make it super clear, like the outcome or the end result is protected under FERPA. You know, see where I'm going with this?
Is that paragraph 4 or where you just were?
Let me look again. Yeah, Ron Raven. Yep, that's fair.
I would maybe add FERPA in parentheses after.
Oh, yeah, make it stand out a little bit.
Because if you don't immerse yourself in this stuff daily, you're not going to read, federal whatever and think, oh, that's FERPA.
Yeah. And it would be laws in the plural. See how after FERPA and other law should be laws. Is there any other laws though? Is that appropriate there, Adam?
FERPA is the biggie about confidentiality and why that's what really prohibits us from sharing the outcome often.
Oh, yeah, I know
Yeah.
the FERPA. I'm just questioning how it says FERPA and any other law. Is there any other law, or is it just good to have it there?
Just in case.
Just in case. For safe measure.
Yeah, I mean, students, discipline or remedial action against the students and the parents. So there are privacy laws regarding the parents.
So HIPAA can come into play,
Yeah.
just depending on the situation.
Good point.
That's fair.
Also, by wording it that way, you leave room for the
Anything
federal
coming down
or
the
state
pike.
to make some new restriction. Technically, they're trying to make laws the other way around to make stuff more disclosable, but
Okay, thank you. I'm good. Oh, wait, one more. That next section below, you've got the number, let's see, under investigative procedures. Let's see, what page is that on? On page 6, we've got 5 days, but we don't have the number word and then parentheses 5 under investigative procedures. So section Roman numeral 9, number 1. So page 6.
Could you repeat?
Or, sorry, not 9. I apologize. Section 11. So it's on page 6 of the document. Roman numeral 11, header of investigative procedures, and then number 1 under that. So see how it says within 5? It's got the number 5, but that should be in parens. It should be within the word 5, parens, number 5.
all right, if we're all set with that, at this point, we'll send it to the board for first read. Probably have to go through all the same discussion again at the full board level, explain why we're even doing anything with it at all. All right, BBBE. This may require no change. It's possible. This is our own policy for what to do in the case of a member vacancy. And as you guys are aware, we will be voting to accept the resignation of Rebecca Lancaster at our next full board meeting and scheduling a date to appoint an interim. And this is the policy that we have to follow for that. I hate this policy. We've already beaten it up twice in my time on the board. It's a little bit better. It has always, to me, felt like, hey, look at us, we're really important. All that we're required to do by the state, and Shana included the NHSBA sample, which is not really a sample, it's more instructions on how to create your own policy. We have to set a date, we have to publicize it, and we have to hold a public vote. It doesn't require us to necessarily bring in the candidates. They can submit their responses in writing. it doesn't require us to create a list of questions as we do. They can just say why they want to run for the board and be done with it. There is an advantage to having the candidates come in person, because after we vote, you can then swear in the person and they're immediately on the board. But I don't know. I mean, we did beat this up pretty seriously, and maybe it's okay, but that's why it's here. And I guess what I'd like to do is bring it to the full board as well and have them say if they think anything looks ridiculous in this at this point. You guys have thoughts on it? Jacqueline, you've been through this process almost as many times as I have at this point.
Did you want to go first, Dylan? It looked like you.
No, I'm all set. I looked through it earlier, and I think we should bring it to the full board.
Yeah, I mean, we most recently reviewed this, and if memory serves, because I was on the board at that time, we did it in 2021, and I think we added some tweaks, and that was at the same time that NHSBA and came out with some new language.
I remember what we did at that one.
Yeah.
Specifically, we put some specificity on what has to go in for notification and advertisement. And we took out the option for the board to ask further questions, right? Because, at least according to our parliamentarian, if we ask a follow-up of one of the candidates, we have to ask the same follow-up to all the candidates. And if the follow-up occurs to us during, say, candidate number 3, then you have to go back and bring back candidates 1 and 2. And so we just eliminated that whole part of the process. So it is better than it used to be. So maybe it's okay as is. I know we always struggled with the create questions.
But we did come up with a good set of questions, as I recall, when we had what was ultimately filled by Ron Wright.
Yep. Yeah, that's right. Ron was the last one to go through this process. All right.
Yeah.
So that's why it's here.
I think you're going to have to follow your policy.
Yeah. Yeah.
And I mean, it's obviously an optional policy. All you really have to do is follow the law to fill that vacancy. But once you've got this policy on the books, you're stuck with it.
No, this is more, do we want to alter the policy?
Right. Do you want to change it? Yeah. And I mean, it really, as long as you follow and I think the NHSBA version gives a pretty good roadmap.
Yeah. The other thing we could do is go through it, because we are going to have to go through it, and then have this discussion immediately afterwards and see who hated it and who loved it.
I'm happy to take a crack at this based off. I would start with the NHSBA version and then add whatever works or didn't work this last go around.
Yeah. Yeah, go ahead, Jacqueline.
I like that idea of having Adam take a review at it, because we did not have Adam on board when we
This has
revised
never
it
been
in
gone through legal,
2021. So that would make me, I guess, I'm comfortable with it now, but I always feel like it's good for us to have something, have a legal set of eyes to sweep through it, catch anything that maybe is out of place, missing, or is solid, and continue.
Yeah. Yeah, we inherited this. This was mostly in place, Rob, when you and I came on board 10 years ago. And we've tried to make it better, but clearly somebody in the past felt that this should be a very formal, I think it was probably modeled after what the city does. So yeah, I think having Adam take a look is probably a good idea, and maybe we'll review again after we, fill Rebecca's seat, see where we are then. So we'll have it go to the full board, not as a first read, but just as a, please take a look at this and tell me what you guys think. All right. That was policies for review. Any updates on policies sent to others or policies on hold, or are those all still in their holding patterns? All right. Under other, policies for renewal. Did Shana put this together, or did NHSBA put this together? Did Adam put this together?
No, this is
I did not.
an NHSBA document.
So the link takes you to, Rob's got it up on the screen. These are all policies, or mostly policies on our book that require actual review and reapproval from the board on a regular basis. I think what I would like to do is, if you guys are comfortable with this, give me this month to take a look at this list, to kind of sort out annual versus biannual versus, I think there's a couple other categories in here too. But I think the obvious way to handle this is the same way that we handle, there's an annual reapproval of all of our policy book. At the same time, we would key out these specific policies and, take a quick run through them here and then bring it to the full board. And I don't think it needs to go through, unless we're going to propose a change, it doesn't need to go through the full process. We can just say these are the annual policies for
Reaffirmation.
Yeah, exactly. So just to make sure that we're in compliance, we'll just take a quick, look at them rather than just including them in our reaffirmation. So, unless you guys have an objection to that.
I'm comfortable with that.
Okay. All right. So we'll. This is April. Next month is May. That works. All right. So I'll have that ready to go for May. Policy on devices with batteries. Rob Millay to explain. I assume you're RM.
This is a follow up to what you shared with us that happened at the high school last month.
Yeah, so it had to do with the computer meltdown over at the high school, and I'm going to get the type of battery wrong, so a little bit removed from that.
Lithium, isn't it?
Yeah, it was a lithium battery. So,
lithium ion.
Yeah, lithium ion battery. So the concern that was shared with us from our partners of the fire department were that, some of these things are found in devices that you may not even think anything about, but they carry bigger or larger lithium ion batteries than a laptop does and can do significantly more harm or danger. For example, a electric bike, an e-bike or a scooter, an e-scooter. And, as the weather starts getting warmer and folks are looking at alternative ways to come to school, whether it's a student or a staff member for that matter, do we really want those vehicles, I guess is what I'd have to call it, parked inside of the building where that battery could have a meltdown and create a lot more trouble than just keeping it from the elements. We've got bike racks at our schools. Folks can chain them up so that they are secure. But if they're indoors, that laptop that had an issue, it only impacted that classroom until we were able to air it out, and then it was fine. But something like that could be much worse. And so we don't have a policy on that. I'm not looking to create a new policy, but it's just something that we might need to think about and propose just for consideration so that our buildings, we're looking at safety from all kinds of different angles. This is just another angle.
So I think we're probably ahead of the NHSBA on this one. There's not a sample policy there. Tim Rohr was telling me that some other districts have existing policies. So rather than inventing one on our own, it might be worth researching who else has them in the state and see if it's something that's applicable to what we're doing.
Yeah, I think we can, troll around the rest of the state, see what else exists, and maybe even cross some borders and see what might exist in other places as well. It's just something that came to light, and it was like, well, wait a minute, we don't have anything that says you can't park your electric bike inside the gymnasium, wherever.
Yeah. We, as a board, will not have a policy in place for you by the end of the school year.
Right.
So if it's something you want happening now, then you and Dr. Gallagher and Mr. Smith will have to.
It would have to be a directive.
Right.
It would have to be a directive. And folks might be upset about that, but just so be aware of that. The other thing, just to kind of keep on the radar, I know it's not on our agenda, is that we've asked the SAU board to consider a policy with regard to how long emails stay in your inbox. And that's because we've gotten into some really bad habits of just keeping all of our emails for decades. And it takes up space, it takes up, a lot. And we have record retention policies. And so if somebody were to do a right to know request, for example, and there was a key word, you would have to go back through all of your emails that have that key word and hand those emails over. If we don't have a policy that says, there every 60 days, your emails are going to be automatically deleted. If you need to keep it, then you need to download it and file it appropriately, if it's something that's vital. And I get it's going to be a huge shift for employees who use that to jog their memory when something, oh yeah, you know what, let me look. And they
Me and Shayna and Kathy.
well, I mistakenly wiped out my whole inbox, not the summer of 24, the summer of 23. And I got to tell you, it was probably the most liberating thing I've ever done. Because, folks were like, oh, you remember that email I sent you 7 years ago? Nope. I honestly don't. And I don't have it anymore. It wasn't intentional. It just, I just screwed up when I still don't know exactly how I did it, but I was like, where did all my emails go?
So the one caveat that I would give you is you will have to provide training to the board. For whatever reason, most of our board members come on not Google proficient. They are more familiar with either Microsoft or
Yeah.
not using email at all.
No, that's very true. And I recognize that. A lot of folks would be like, well, what do I do? How do I archive? How do I download it? How do I put it into a separate file because it's needed to be saved? There are very few things that actually need to be saved, and we just got to recognize that.
That was going to be my added point is that,
sorry, George.
yeah, with very few exceptions, most of our emails don't actually, we get occasionally some that actually constitute notification by some of these policies, and that obviously has to be redirected where it gets redirected, and those have to be saved. But other than that, yeah, everything else falls under the specific FOIA that this policy would be addressing. So, yeah.
So just wanted to give this committee a heads up that we've asked the SAU board to take a look at a policy, because then my assumption would be that if the SAU board does pass that for central office, then all of our districts would need to be looking at that too. And we wouldn't say, all right, starting tomorrow. We would say, look, effective January 1st or something like that.
I appreciate that, but I'm not going back through 10 years of emails before I archive them either.
Yeah.
I'm looking at like the last month.
Just delete them. I'm not going through it. Yep.
Yeah. Adam, you started to say something about the
two
EV
things.
battery,
The batteries.
yeah.
I looked at some of the policies. Most of them are at the college level, and they just say no electrically powered vehicles inside any buildings at all. So that covers your hoverboards, your scooters, your bicycles, everything. They just say none.
Teslas in the
Yeah,
automotive
Teslas,
shop.
none of it. Nothing can come in if it's powered by batteries. Motorized vehicle. And then Jacqueline had something. She was raising her hand. You didn't see her because she's behind you.
Sorry.
That was my other thing.
That's okay. Okay, so talking about the bikes first, and then I want to mention something about the emails. Do we not have a policy in place already for bicycles to not be in the building? And where I'm going with this is if we do, then all we simply need to do is revise that existing policy.
That feels building specific to me rather than a school board policy.
Well, I don't know. I'm just asking if we've already got something on the books.
Yeah, I can't think of one that we have. Okay. I think it's more of a site-based management thing, meaning the middle school puts it into their handbook. If you ride, you must have your helmet on, and you must park your bike over at the bike rack and lock it up.
Right.
But it's not an official
Right.
policy.
So if we don't, I personally feel pretty strongly about this, that this is a policy that needs to be in place as soon as possible. I recognize it probably won't be possible to happen before the end of the school year, but I feel pretty strongly that this needs to be in place for the start of the school year, not only for the safety of everybody in the building, but our buildings cost a lot of money, right? Like I know I'm preaching the choir. We have a lot invested in our buildings that to me this is straightforward. You've seen enough on the news in various apartments, places across the country. It does a lot of damage. So I feel that this is something we've got to get nailed down sooner than later.
Yeah. In the absence of policy, that's one of the things that I do appreciate is that in the absence of policy, we are able to put out directives to that nature. Um, the push will come back. Well, you don't have a policy that says I can't do it. And it's like, yep. So, in the absence of policy, this is the directive. You're not happy with my decision, by all means, appeal that through our normal
Yep.
chain of complaint. And we do have a policy for a chain of complaint.
So I don't know if that means then that we discuss this at full board and we do a direct the superintendent to, you know,
The directive will be in place before you meet.
that is great. All right. So then going back to the email, maybe I've misunderstood you, but if you're bringing up first to the SAU 29 board, I was thinking you were meaning archiving of emails for everybody associated with an SAU 29 email, and it somehow seemed to have gotten off track that this is just a board thing, and
No, it's
it
not just
shouldn't
a
be.
board thing.
Okay,
It is
all
for
right.
all employees. I
That's
think
yeah.
that George was just requesting for training for board members who might
Right.
not be as
That's right, and
proficient.
that's
I
separate.
think that
Yeah.
was just kind of a parallel side note, is all that was.
Yeah, the fact
Gotcha.
that all of our emails are sau29.org is
Yeah,
kind
and
of makes it
that's
makes
where
it a
you're
little
throwing
bit
me off
confusing,
because you were
right?
sort of going into training and
Yeah,
then
no, the initial point was really for initially it was for the SAU 29 office staff, the Colt staff, and
yeah.
their direct reports, and then that would then extend to your buildings, to Chesterfield's buildings, etc. And technically we get paid by the Keene School District.
Oh
So
yeah, no, I get why I have an
yeah,
email. It was just
ultimately
you
apply to
threw
us
me off
too, right?
respectfully, George. You threw me off where you were honing in on just the board, and I'm thinking, this was all of us.
Well,
Yeah.
training for other people, that's up to him.
Yeah. It's pretty standard nowadays in the private sector. It's made clear to employees that emails are only kept for 2 years, 4 years. At my company, it's 5 years, which even that I think is pretty overtly generous. Saving data costs money, so it's time for us to, in my opinion, tamp that down because that does cost a lot of money for us to keep maintaining all of this. Yep.
So, Rob, will you have somebody at your office dig around for what we want to do for a vehicle or an EV policy? All right. Anything else before the policy committee this month?